I'm a proud member of the Samuel Griffith Society, have been for many years. I always enjoy attending the conferences when I can. I'm sorry that we can't have one this year, but I'm looking forward to heading to the next one next year when things hopefully have returned to normal. Can I add my recognition to all the members and supporters of the Samuel Griffith Society who are on the call, particularly to my colleague, Senator Abetz, and many good friends I can see through the screen looking back at me, and I look forward to a beer by the bar at the next conference next year. Turning to the paper now, the topic of the paper tonight is on the Love decision, which you're all very familiar with, but I've got some observations to make about the implications for it for constitutional recognition, and of course also High Court appointments. And I look forward to your feedback and your comments and your questions at the end. The High Court's decision to exempt Indigenous people from aspects of Australia's immigration law amounts to a radical change to constitutional law that will have profound implications for many years to come. Ruling in the case of Love v Commonwealth, a narrow High Court majority of 4-3 determined that Aboriginal Australians are outside the scope of the Parliament's power to make laws with respect to naturalisation and aliens, the constitutional provision that forms the basis for the Migration Act 1958. In effect, the Court's majority created a new category of a non-citizen, non-alien, which grants immunity from deportation to members of Indigenous communities, regardless of whether or not they are Australian citizens. As all three dissenting justices made clear, the decision comes perilously close to granting sovereignty to Indigenous communities. It raises questions about the place of Indigenous Australians in our political system, and it undermines the fundamental principles of equality, the rule of law, and the nature of our democratic system of government. It is a warning of the risks of recognising Indigenous Australians in the Constitution, and a reminder of the importance of considering the judicial philosophy of candidates for appointment to the High Court. This should include an intellectually honest discussion about the stark differences between being a constitutional conservative and a political conservative. The case before the court involved two foreign citizens who had their visas cancelled for character reasons after each was separately convicted of assault occasioning bodily harm. Both men were taken into immigration detention in order to await deportation. On the day they were set to be released on parole. The case could have been fairly straightforward if not for the men's Aboriginal identity. Daniel Love and Brendan Thoms were both born overseas. Daniel Love is a citizen of Papua New Guinea who has resided in Australia in a permanent residency visa since he was 6 years old. His father was an Australian citizen, and he is a descendant of Aboriginal Australians who inhabited Australia prior to European settlement. He identifies as a member of the Kamilaroi tribe and is recognised as a member by the elder of that community. Brendan Thoms, on the other hand, was born in New Zealand to an Aboriginal Australian mother and a New Zealand father. He is a citizen of his country by birth. But like Love, he moved to Australia in his early childhood. Thoms is a descendant of the Gungari people, and he both identifies and is accepted as a member of the community, and he is a common law holder of native title. As plaintiffs in the case, Love and Thoms argued that even though they are not Australian citizens, as Indigenous Australians, they have a special connection to Australia and therefore cannot be considered aliens within the meaning of Section 51 of the Constitution. As a result, they each have a continuing right to remain in Australia, regardless of whether or not they have citizenship or even a valid visa. Justice Stephen Gagler, one of the three dissenting judges, described this as a novel argument, and that though it is morally and emotionally engaging, he says it's not legally sustainable. While both Justice Patrick Keane and the Chief Justice Mary Kiefel agreed with Gagler's assessment, the remaining four justices sided with the plaintiffs in a decision that is sure to have profound consequences for many years to come. Justices Bell, Gordon, Edelman and Nettle all wrote their own separate judgments. They agreed that the Parliament could not treat an Aboriginal man as an alien because they did not meet the description according to the ordinary understanding of the word. The four justices were also united in their recognition of the importance of the connection that Indigenous Australians have with the land. Justice Bell argued that this connection was essentially spiritual, and for Justice Nettle, this spiritual connection runs deeper than the accident of birth in the territory or immediate parentage. According to Justice Gordon, this spiritual and metaphysical connection was the deeper truth underlying the decision of Mabo v Queensland. Gordon also argued that one of the central pillars of Mabo was that the common law recognises that Indigenous peoples can and do possess certain rights and duties that non-Indigenous Australians do not and cannot possess. Justice Edelman not only claimed that Aboriginal people are tied to the land through metaphysical bonds far stronger than those of birth or nationality, but those bonds are an underlying fundamental truth that cannot be altered or deemed not to exist by legislation. To say that the three dissenting justices disagreed with their colleagues in the majority is an understatement. The Chief Justice asserted that by ruling on whether the plaintiffs are aliens, the court was usurping the role of Parliament. This is an important point about the nature of our democratic political system. But the High Court's decision not only usurps the role of the Parliament, it also deprives Australian citizens of their rights to determine the laws under which they live. Justice Keane took aim at the majority's misreading of Mabo, pointing out that while the common law recognised native title, it does not entail to the recognition of an Aboriginal community's laws. Justice Gageler's strongest point undoubtedly came on the issue of equality before the law. Realising the likely racial division that the majority was creating, Gageler said that he could not be party to a process of constitutional interpretation or constitutional implication that would result in the inference of race-based constitutional limitation on legislative power. In his view, it is not within the scope of the acknowledged judicial function. But it's on the issue of sovereignty that the dissenting judges were most united in their criticism. The majority had agreed that in determining their Aboriginality, the court should rely on the tripartite test outlined by Justice Brennan in Mabo. According to this standard, for an individual to be a member of an Indigenous community, they must be a person of Aboriginal descent, they must identify as a member of an Indigenous community, and they must be accepted as a member of that by that same Indigenous community. This tripartite test has become very commonly used in native title cases. The problem is, though, that by ruling that Aboriginal people cannot be considered aliens and then using the tripartite test to determine Aboriginality, the High Court has effectively granted Indigenous communities a measure of sovereignty that the Parliament has not even considered, let alone agreed to. All dissenting justices condemned this. Justice Keane said, to suggest members of Aboriginal groups have authority to make choices that bind the Commonwealth of Australia is to attribute to those persons a measure of political sovereignty. All three justices also pointed out that this is contrary to Mabo and subsequent cases that have all rejected Aboriginal sovereignty whenever it has been raised. A robust and forthright criticism from these three dissenting justices did little to dampen the enthusiasm with which many prominent Indigenous Australians greeted the High Court's decision. Indigenous journalist and author Stan Grant said the decision was one of the most remarkable documents I've ever read in Australia, and that the judge's opinions were profound, wise and sensitive. Grant was joined in celebration by the Labor MP Linda Burney, who is both a Wiradjuri woman and a Shadow Minister for Indigenous Australians. Burney described the judgment as incredibly significant because it reaffirms the important connection, the special connection that Aboriginal people have to Australia and their historical connection. However, as supporters of an Indigenous voice to Parliament, Burney and Grant ought to stop to consider the implications of the High Court's decision on the campaign for constitutional recognition of Indigenous Australians. This is because the High Court's decision is likely to only increase the natural scepticism and caution most Australians have about constitutional change, such as the creation of a voice to Parliament. This realisation prompted Father Frank Brennan to tell the Sydney Morning Herald, "My heart sank when I heard the news." As he explained, there goes the voice to Parliament, there goes anything in the form of constitutional recognition through a referendum. That sentiment was echoed by Chris Kenny, who's also a supporter of the voice proposal. He wrote that a complex and historic area of national and Indigenous reform has been jeopardised by the ruling of 4 High Court judges. What both Brennan and Kenny realise is that the High Court's decision perfectly illustrates the warnings constitutional conservatives have long been making about the legal risks of recognising Indigenous Australians in the Constitution. As many of us have warned, all forms of Indigenous recognition, even symbolic proposals such as the addition of a preamble, carry legal risk. If this is what the current High Court, a majority of whose justices were appointed by coalition governments, can do with a narrow and conservatively drafted constitution, imagine what a future, even more activist court could do with an Indigenous voice to Parliament. It is not difficult to imagine how its role could one day be expanded by a future High Court well beyond its intended design. The risk that a voice to Parliament could become or be seen as a third chamber of Parliament was cited by the former Prime Minister Malcolm Turnbull when he rejected the idea as being neither desirable nor capable of winning acceptance in a referendum, after it was first proposed by the Referendum Council in 2017. Of course, the claim that an Indigenous voice to Parliament would be a third chamber has been criticised by advocates of the proposal, with Noel Pearson calling it ridiculous and dishonest. But it is a lot harder to dismiss the risk that a future High Court and its decisions of a future High Court could grant additional powers to a representative body for Indigenous Australians when the High Court has just effectively created a new right for members of Indigenous communities, regardless of whether or not they are Australian citizens, which in the words of Chief Justice Kiefel, is of such a nature that it may not be altered either by statute or by the Constitution. It is possible, for example, that a future High Court could view the Voice to Parliament as the legitimate representative body of Indigenous people in Australia, and the partial sovereignty that it has created in this case could be vested instead with this voice. With this change alone, the Voice to Parliament would resemble much more than a de facto third chamber of Parliament. It would in fact be an alternative representative body with its own exclusive powers. Now that may seem far-fetched, but in fact, as Justice Gageler wrote in his dissents, to concede the capacity to decide who is and who is not an alien from the perspective of the body politic of the Commonwealth of Australia to a traditional Aboriginal or Torres Strait Islander society, or to a contemporary Aboriginal or Torres Strait Islander community, or to any other discrete segment of the people of Australia, would be to concede a constitutional capacity greater than that conferred on any state parliament. By revealing this risk to the general public, the High Court has almost certainly made it more difficult for most, if not all, Indigenous recognition proposals to gain the necessary double majority required at a referendum. Section 128 grants the Australian people the exclusive right to change the Constitution. Unfortunately, as has now been made abundantly clear, the High Court is more than willing to decide cases in ways which radically alter the meaning of the Constitution. As Emeritus Professor Geoffrey Goldsworthy argues, this equates to changing the Constitution itself. These changes don't just occur in the area of Indigenous affairs. As we know, in the area of federalism, for example, since Federation, there's been a whole range of cases that have radically altered the division of powers between the Commonwealth and state governments. The Engineers case, the first and second uniform tax cases, and the Work Choices case are just some of the more prominent alterations to our federal structure. And as a result of these and other decisions, Australia has now one of the most centralised federal systems in the world. In other words, unless something is done to reduce the level of judicial activism on the High Court, advocates of Indigenous recognition could end up getting all of the constitutional changes they want without ever needing to win a democratic mandate at a referendum. The High Court's decision in Love v Commonwealth has already sparked a considerable debate about judicial activism, the appointment of judges, and the politicisation of our courts. In a series of criticisms of the High Court's decision, the University of Queensland's Garrick Professor of Law, James Allen, took aim at the coalition government's record on judicial appointments, pointing out that 3 of the 4 judges who sided with the majority were nominated by Attorney General George Brandis during the Abbott and Turnbull governments. Allen described this as astounding and asserts that we now have to rely on Labor to give us constitutional conservatives, as they did well with Gageler and Keane. In a similarly critical piece, which prompted its own flurry of responses from the legal community, the Institute of Public Affairs research fellow Morgan Begg called for the appointment of justices who are capital C conservatives. According to the University of New South Wales Dean of Law, George Williams, the attempt to appoint judges based on their political views would undermine public confidence in the judicial system and result in a US-style system of hyper-partisan appointments. The Judicial Conference of Australia President Justice Judith Kelly echoed these points, arguing that Australia had fortunately avoided the approach adopted in the US. For his part, George Brandis responded to James Allen's critique by explaining that he was only ever concerned with one thing when nominating judges: their eminence and ability as lawyers. He too warned that an ideological test for judicial appointments would politicise the judiciary and undermine public confidence in its impartiality. Brandis is right to highlight the importance of legal ability as a criteria for appointing judges. It is a self-evidently appropriate criteria for the appointment to any court, but it should not be the only factor when considering an individual as a potential High Court justice. Appointment to the High Court comes with enormous responsibility and considerable influence over Australia's political system. During their secured tenure on the court, judges are nothing short of guardians of the Australian Constitution. Because of this, Australian governments should absolutely consider the judicial philosophy of the candidates, and to do otherwise is to gamble with the future of our political system. None of this is to say that a candidate's political views ought to matter. It is irrelevant who a judge votes for, and it ought to remain so. It shouldn't matter whether the judge supports privatisation or greater action on climate change, or what their views are on foreign policy. Morgan Begg expanded on his position with the following comments to the Australian's Chris Merritt. Being a legal conservative means being a unifier, not a divider. It means interpreting the Australian Constitution in a way that was originally intended at federation, including by correcting the massive centralisation of power in Canberra and restoring powers to the states. In the words of James Allen, we want people who interpret the Constitution the way it was intended, to leave these big ticket issues to the elected parliament. It is the judges' interpretive views that matter, not their political druthers. Clearly, both Allen and Begg are calling for the appointment of originalist judges who will use the original meaning of the Constitution as a guide through which to approach cases. The benefits of this approach is that it preserves the scope of democratic decision-making and constrains judges' ability to make their own personal views and decisions. This allows political decisions to be worked out organically through the democratic process. In the long run, it is far more likely to maintain social harmony than if decisions are imposed from above by the courts. Originalism is far from the only judicial philosophy, and it is certainly not the dominant approach being followed on the High Court, but it is well known. So it is rather surprising that three eminent members of the legal establishment mistakenly assumed that constitutional conservatives were advocating for judges to be appointed according to their political rather than judicial views. Perhaps it is the term capital C conservative which has confused them. But labels should not matter. What is clearly being called for is judges who respect the sovereignty of the parliament and don't believe it is the role for the court to effectively take major and contentious public policy decisions out of the hands of the voters in a democracy. Ironically, for all the concern about the danger of politicising the courts, it is activist decisions like this Indigenous Affairs case that polarise the community and create dynamics for politicisation to occur. Cases that confirm the existing understanding of the Constitution and leave policy decisions to democratic elected parliaments to resolve, by definition, are uncontroversial. It is the cases that fundamentally transform our system of government, take decisions out of the hands of the people, or suddenly introduce new rights that lead to public discontent and reduce trust in the judiciary. When this continually occurs, politicisation is the inevitable result. This debate around the appointment of judges has suddenly flared up. It is a case in point. No doubt there were already plenty of people already opposed to the direction of the High Court, but it was the shock decision to exempt members of the Indigenous communities from the Migration Act that sparked a rush of calls to reform. In fact, along with the existence of the US Bill of Rights, headline-grabbing activist cases are exactly what led to US judicial appointments becoming so politicised. The growth of the conservative legal movement and the importance of judicial appointments in the political process only began after a series of judgments from activist judges that catapulted the issue of judicial appointments into the political debate. One of the biggest turning points was the case of Roe v. Wade, the decision that legalised abortion on the basis of privacy. Putting the respective merits of the issues aside, it is clear that the decision in Roe v. Wade was a shock to the American political system, as advocates on both sides turned their long-term attention to the Supreme Court. It galvanised millions of pro-life voters to campaign for and donate to politicians who would appoint conservative judgments. This is not to say that the conservative legal movement in the US is all or even mostly about abortion, but it is unlikely the appointment process would have become so political, if not for activist decisions that brought contentious policy issues into the judicial realm. No one wants to see Australia emulate that kind of hyper-partisan battles that have come to characterise the Supreme Court nomination process in the US. As we don't have a constitutional Bill of Rights, there is far less scope for the court to be dragged into highly contentious political debates. The lack of a Senate confirmation process also removes one of the very public avenues for political grandstanding when it comes to the appointment of judges. But every time the High Court usurps the role of the Parliament, changes the division of powers, or suddenly discovers a new right, we take a step towards a more politicised judicial system. The High Court's decision in Love is understandably viewed as a historic decision by many Indigenous Australians. But regardless of its symbolic importance, the High Court's decision should ring alarm bells for Australians concerned about our democratic system of government. By exempting members of Indigenous communities from the Migration Act, regardless of whether or not they're Australian citizens, the High Court has created a racial division within the Constitution that voters may never have agreed to if given the opportunity at a referendum. The decision is a warning about the risks of constitutional change, especially the proposal to constitutionally enshrine an Indigenous voice to Parliament. It should act as a wake-up call for the need to consider judicial philosophy of the judges that we appoint to the High Court. This is not just an issue of concern for constitutional conservatives, it is an issue that should concern all Australians who value our enviable constitutional democracy.